The government of Australia passes extreme social media legislation into law which allows them to punish individuals and corporations, including social media executives, with heavy fines and jail times for failure to block or remove violent content from their platforms. A step in the right direction to fight violent extremism worldwide, or another step towards a nightmarish dystopia? I'm your host, B.A. Jarvis, and you're watching The Golden Door. All right, we're back, and not too soon as the governments of the Western world continue to lose their collective minds. It's been less than a month since the horrific events at Christchurch, and in that time, Western democracies have been unrelenting in their desire not to let a tragedy go to waste. New Zealand passed some pretty extreme legislation in response to the events, including serious jail time for possession or distribution of the killer's livestream video and manifesto, as well as sweeping changes to its firearm legislation with little to no public consultation. Not only is the efficacy of these legal responses to prevent another similar tragedy questionable, it's worrying that countries seem so eager to do away with the legislative process and debate for the appearance of acting swiftly to address the apparent rise in global threat of white supremacy. On April 3rd, the Australian Parliament introduced a criminal code amendment on the sharing of abhorrent violent material, at which time the legislation was read by Parliament for the first time, passed by the Australian Senate on the same day, and officially brought into law the next day on April 4th, allowing for no public, industry, or expert consultation on the amendment. As a result, the law has faced heavy criticism from the public, the industry, and the experts. As cited from the United Nations Human Rights Special Procedures Rapporteur, the law fails key state obligations for the International Covenant on Civil and Political Rights, ratified by Australia in 1980, specifically relating to Article 19, Sections 1 to 3 of the Covenant. Under Section 474.31, abhorrent violent material refers to any material that records or streams abhorrent violent conduct and is produced by a person or persons engaging in, conspiring to engage in, aiding or assisting in, or attempting to engage in such conduct. It further defines abhorrent violent conduct as engaging in a terrorist act, murder, attempted murder, torture, rape, or kidnapping. The law provides that it is immaterial whether the abhorrent violent conduct was engaged in within or outside of Australia. Punishments related to the offense are severe. Under Section 474.33 of the law, Internet content and hosting service providers are obliged to report to the Australian Federal Police the existence of abhorrent violent material that records or streams relevant conduct occurring in Australia. The failure to report such material within a reasonable time after becoming aware of it constitutes an offense. Offenses committed under 474.33 are punishable by fines of up to 168,000 AUD for an individual or 840,000 AUD for a corporation. Under Section 474.34, content and hosting service providers commit an offense if they fail to expeditiously remove abhorrent violent material that is reasonably capable of being accessed within Australia. Offenses committed under 474.34 are punishable by up to 3 years imprisonment, fines of up to 2.1 million AUD for both an individual, and fines of up to 10% of a provider's annual turnover for a corporation. Among the concerns raised by the UN Human Rights Rapporteur are as follows. To begin with, we are especially concerned that the unusually compressed timeline for debating and passing the law failed to provide your government or members of parliament with sufficient opportunity to consult with civil society and the public on the complex issues it raises. We are mindful that depictions of egregious violence on the internet provoke legitimate concerns about public order and safety, and for that, for a variety of reasons, the prevention of the dissemination of such images would be in the public interest. However, it is precisely the gravity of these measures and their potential impact on freedom of expression that demand a thorough and comprehensive review of the appropriate legislative and other regulatory response. Limitations on the legislative process in these circumstances may amount to an unreasonable restriction on the right and the opportunity of citizens to take part in the conduct of public affairs directly or through freely chosen representatives, as provided under Article 25 of the ICCPR. Ambiguities in the law demonstrate why public consultation and debate are warranted. For instance, the obligations to expeditiously remove content reported to law enforcement within a reasonable time frame raise questions about how quickly service providers are expected to flag and identify offending content and take appropriate action. Short timelines pose highly negative implications on the practical realization of protection of freedom of expression and interlinked rights in real time. We are concerned about accelerated timelines will not allow internet platforms sufficient time to examine requests in detail and may in practice mean that providers will consequently produce an abundance of caution for concern of financial fines and other consequences. These relationships between the notices issued by the e-Safety Commissioner and these obligations is also unclear. Does the time period for calculating whether offending content that has been expeditiously removed or reported within a reasonable time frame begin at the point of upload or upon the issuances of these notices? If the Commissioner does not issue a notice until after the offending content was removed or reported, how would this affect the prosecution's assessment of whether a service provider has complied with its obligations under Section 474.33 and 474.34? These are precisely the sorts of questions that may be clarified through regular legislative process and a call for public comment. The document continues on for a while, and I'm not going to go through all of their argumentation, but I will provide a link in the description below. As others have pointed out, one of the main issues with this legislation is that it seems to shift the burden of onus of proof from the state onto the organization or corporation that's been charged, essentially guilty until proven innocent. The law does list several defenses for failure to expeditiously remove such content. The bill states, such failure is not an offense if accessibility is, among other things, necessary to assist in investigations of violations of domestic or foreign law, necessary to conduct scientific, medical, or academic or historical research, relates to a news report or current affairs report that is in the public interest and is made by a person working in a professional capacity as a journalist, or relates to an artistic work. Among other concerns are that the law makes no exemption for whistleblowers attempting to highlight human rights abuses and potentially requires social media companies to breach privacy laws to enforce. The law also fails to define terrorist act, which ensures that the government of the day can apply this standard to whatever violent content they wish. Another term missing definition is expeditious, which leaves the question of how long a content provider or platform has to remove the material, although the hour and 10 minutes it took for them to remove the Christchurch shooter video was apparently too long for comfort for the legislators. The UN rapporteur was apparently intending to present this evidence during the deliberation process of the law, but the legislation was passed too quickly by the government to allow that to happen. Not content to simply subject their own country to this poorly conceived, woefully underdebated, and hastily passed legislation, the Australian Parliament is hoping that other countries will adopt this approach as well, and that it becomes the UN standard. Australia is dealing very poorly with some serious guilt over the fact that the Christchurch shooter was an Australian national, and heading into an election has a burning desire to blame its society for the radicalization of this man, as though racism and Islamophobia of this kind are somehow ingrained and taught as part of Australian culture. If this was the case, we would likely have seen more evidence of this. Not necessarily more violent acts, but at least perhaps some groups or prominent individuals coming out and celebrating the act. But so far, the only stories I've seen was a report that some Steam accounts got banned, and a report of one man in the UAE who was fired and deported for allegedly celebrating the attack on his personal Facebook page. So aside from anonymous accounts, this amounts to one person globally, and yet we're supposed to swallow the narrative that white supremacy is a widespread global threat. As I've stated in a few previous videos now, if there is a legitimate increase in the prevalence of far-right ideology, mainstream media reporting and social media censorship are at least partially to blame and are only serving to make matters worse by pushing those who could be de-radicalized into deeper and darker corners of the internet and broader society. I'm having a hard time understanding how a Western democracy could be this short-sighted. Just because something terrible happens doesn't mean you need to pass a law in 2 days. Imagine a scenario where your government or a foreign group does something really violent and abhorrent to its own citizens. This law has effectively just severely curtailed social media as a journalistic means of calling attention to the event or of legitimate civil protest within Australia. It seems to me that if you're an elected representative in a democratic Western society, before you vote for any law, you should ask yourself, does this law make us more like a dystopian civilization found in the works of science fiction, or less like a dystopian civilization found in the works of science fiction? If it's more, don't vote for the law. If you're an elected official and your party supports a law like this, you have an obligation to stand up, raise your voice, and vote your conscience. If your elected official has already voted for a law like this, you as a private citizen have an obligation to take them to task. Our collective failure to do so will turn our beautiful society into a nightmare we can't even fully imagine. Alright, as always, thanks again for watching the video. If you want to see more content like this, don't forget to hit the like and subscribe button, and stay tuned because we've got a few more videos coming up that I think you'll be interested in. Until next time, you've been watching The Golden Door.